Hello, everyone. Thank you so much for joining us today. I'm Annalise Proudhummel.
I'm Doug Kahn. Thank you very much for being with us today.
We are here to talk about supplemental needs trusts. When do we need them and how do we make them work best? Doug and I are both attorneys here at Unreturner Burke and Freeze. We work in our Phoenixville office, but we also have offices in Westchester. And we are part of the Trust and Estates group. And one of the big parts of our practice area is helping clients that have loved ones and beneficiaries that they want to include in their estate plans that have special needs of some sort. And we get lots of questions about these kinds of trusts and how folks can implement them. And so we wanted to create an educational program for you that gives you some additional information and talk through what some of the benefits are and how you can use these trusts in your planning. We have, as a very first step before we dig into all of the details, a little disclaimer that we have to provide. This is not legal advice. Everything that we're about to talk to you about today, everybody's circumstances and situations are unique and different. And so this is intended to be a general educational program that provides basic concepts and such. Your particular needs and the needs of your beneficiaries and loved ones could vary greatly and be impacted in a way that maybe what we're talking about today wouldn't necessarily apply. So our goal here is to just give you this kind of basis to get some basic info and build on that for your particular needs. Let's talk then about why exactly we're here, what we're going to cover today, who would benefit from the information that we're going to talk about, what our goals are, our objectives. Just sort of in a nutshell, as I said, we're here to educate folks, parents and grandparents of minor children, adult children, grandchildren who are disabled, differently abled, or have special needs of any sort. If you're a special needs person that's in your life is not a child or a grandchild, is a spouse, is a sibling, or another loved one, this presentation is still, 100% for you. This trust planning can benefit anybody. And Doug and I were talking right before we started recording, doesn't mean that you have to have sort of a diagnosed special need also. Could be something that you're just looking to provide some protection and some benefits to beneficiaries. And I think that'll all become clear as we move through our slides and our information today. We're going to spend our time together today really learning about trust planning opportunities that can help protect loved ones that have these, if it's a disability, a special need, or just something that's really unique in their circumstances that they could benefit from this planning. Particularly with a focus on preserving assets and protecting them from the need to spend down on things like Medicaid, SSI, that supplemental security income. Key takeaways, things that we're really going to impart to you today that we hope that you'll feel more informed about when we're done. What are supplemental needs trusts? When are they needed or beneficial? Different types of supplemental needs trusts and their uses. How do we create these trusts? How do we fund them? How do we administer them? And some common mistakes, missteps, pitfalls, things that can have negative consequences that we want to help you avoid. Specifically, one of the things that we'll talk about is what supplemental needs trusts actually are. I'll give you a little spoiler alert. They are the same things as special needs trusts. So you hear supplemental needs trust, special needs trust, and you think, well, is there a difference? Are these the same thing? It's really a semantics issue. They are the same thing. The terms are used interchangeably. These kinds of trusts are designed to protect assets and preserve government benefits for individuals that have these special needs and disabilities. The key difference sort of between the two historically was based on, like, are these trusts for the needs of the beneficiary versus the trust's role in supplementing government assistance. And so over time, just kind of legislative changes and such, folks referred to these different trusts as being these kind of different entities with different focuses. And over time, they've really kind of streamlined and said, these are the trusts. You'll hear people say both, and neither is incorrect. There's different types of supplemental needs and special needs trusts that are created in different ways, and they serve somewhat different purposes. We're going to talk about these distinctions and the different goals that they can achieve. We're also going to cover the nuts and bolts, so to speak, how these trusts are created, how they're funded, how they're administered or kind of operated, I think you can think of over time. There's some case studies that we have included. We won't dive into great detail on those while we're together here today, but they're included in the materials, and it gives you some really concrete examples about the concepts that we're talking about. And let's see, but wait, there's more. In addition to everything that I just mentioned, we're also going to identify just those missteps, those pitfalls, things that can occur that could cause an unintended consequence result, something that you wouldn't want to happen, so that you can take the appropriate steps to avoid them, not put your loved ones in any kind of jeopardy, or create a circumstance for them that you were not intending. So I'm going to turn it over to Doug now. He's going to start diving into some of these weeds and give you some of this information, and we'll kind of switch back and forth as we go.
Great. Thanks, Annalise. Thanks for the introduction. So these supplemental needs trusts, which we'll refer to throughout, are an extremely important part of the planning process for many of our clients. They have family members or loved ones who have a disability or just an actual inability to manage assets for themselves. So it doesn't even have to be something that's diagnosed. It could be just an awareness that a beneficiary will not properly manage assets for themselves. And maybe there are maybe a little bit more extreme measures that need to be taken in order to provide for that beneficiary properly, and also allow for that particular beneficiary to continue to qualify for benefits that they're receiving, like Medicaid or supplemental security income, which we refer to as SSI. It's also important to know that we can create these trusts to be active immediately. Those would be called inter vivos, meaning during your lifetime. So you're coming to us saying, you know what, I want to start to fund this trust now for this particular beneficiary, and here's why. And then we'd say, okay, well, we're going to establish a trust presently, and that's going to be an active trust. And we'd set all the rules out, and it'd be actively managed as soon as the client starts to add assets to the trust. And you just kind of compare that to a trust that we're creating for a future event that is at the time you pass away. You want your distribution from the estate to go to your beneficiary, but for the distribution to be held in this supplemental needs trust. So we're writing that into a will, which we refer to as a testamentary trust. So either is perfectly fine, really depends on what your goals are and whether you're going to be funding that trust immediately, or if you're going to be distributing assets to a beneficiary at the time you passed away. Although I will say, Annalise and I were also talking about another topic earlier before we got on. That was, what if you had multiple family members who wanted to contribute to the same trust? That might be more difficult if you establish the only supplemental needs trust underneath of a will, because it doesn't really exist until that person who created the will passes away. So in those situations where you might have an aunt, an uncle, brother, sister, multiple parents, all wanting to contribute to the same trust, might be that you decide to create an irrevocable lifetime trust that's sort of sitting there, and each of these different individuals who wants to contribute to it can either contribute to it while they're alive, or underneath of their own planning, they can designate that trust to be a partial beneficiary of their estate. So it's just a good solution for having multiple people contribute to the same trust. Okay. It's important to know probably more so for us than for you, because I don't know if you're going to want to go and read all of these laws, but we just want you to know that there are a lot of legal issues related to the supplemental needs trusts. And we're just listing a few of the statutory provisions that if you are interested, you could take a look at. One is the Pennsylvania Uniform Trust Act, which people refer to as PUTA. And then there's, of course, Pennsylvania case law for our clients here in Pennsylvania. So there have been cases in the past and how they're decided by the courts. Very important from our perspective. We take a look at those, make sure that we're drafting trust for our clients in a way that will pass muster if there are issues that arise ultimately and they come under scrutiny. There are, of course, federal regulations relating to the benefits that individuals are trying to qualify for. So if your beneficiary is receiving Medicaid or Social Security, and you want to maintain their eligibility, the federal regulations have spoken about these kinds of trusts and what assets will cause that particular beneficiary to be disqualified from receiving the benefits. So we, of course, will write these supplemental needs trusts in a way that mesh with the legal issues. And we know, what does the trust need to say in order to allow for the beneficiary to continue to receive the government benefits? So, of course, we're keeping up on all of these things, so you don't necessarily have to read them all. But, again, if you have some extra time for a little light reading, you're welcome to dive into the Pennsylvania Uniform Trust Act and read about the Medicaid rules and Social Security eligibility rules. So those are up there for you to take a look at. We want you to know that we also will draft these trusts to be flexible and adaptable over time. So we are giving the trustees a lot of powers, but we're referencing one here, which is the ability to move the trust to another state. So even though Pennsylvania is the original state where the laws of our state will apply to these trusts that we're creating, if you end up having a beneficiary who moves to a different location and maybe those rules in that particular state are more favorable for one reason or another, maybe preferable tax laws or asset protection rules, they have the ability, based on what we write into the trust, to move the trust to another jurisdiction. So that's called changing the trust situs. So we always want to see that clause in the document. So we are giving the trustees a lot of flexibility and adaptability when they are taking over. Okay. So why are these trusts so important? I mean, the number one reason that you'll see individuals talking about creating these trusts for their beneficiaries is to both provide for the beneficiary, but also allow that beneficiary to continue to receive the government benefits that they're receiving at the time. So again, Medicaid and Social Security are the first and foremost. There are other public benefits out there. There could even be private benefits that someone's receiving. And we're always mindful of those, but a client will have to, of course, let us know if there's something out there that's a special situation, and then we'd have to look at that individually. But I'd say Medicaid and Social Security benefits are the number one concern. And so the idea is put these assets in trust, put somebody else in charge as the trustee. They're managing the assets for that beneficiary. And if we have the magic language in this supplemental needs trust, even though that trust is sitting there, and even though that particular beneficiary is an eligible recipient of assets from the trust, they can still qualify for Medicaid and Social Security benefits. So that's the idea. We want to make sure they keep those benefits even after the assets go into the trust. Of course, we want to enhance the quality of life for the beneficiary. So the trust will allow for the trustee, who's the person in charge or the entity that's in charge, to make distributions for that beneficiary for all kinds of things. It's at the trustee's sole and absolute discretion, but they can use it for things like education, recreation, transportation, and care. So as long as they're doing it intelligently and based on the rules, the distributions for that particular beneficiary will not cause them to lose their eligibility for these benefits like Social Security and Medicaid. The trusts provide a huge level of asset protection. So we want to protect these assets for the beneficiaries, not only so that they can qualify for these benefits, but also recognizing that there could be other liability issues that that beneficiary might confront. So if that beneficiary were ever married and divorced, or had a creditor, or had a lawsuit against them, whatever the liability risk might be, the assets inside of the Supplemental Needs Trust will be protected. These trusts are have such a high level of protection because we're putting someone else in charge, and that person, or it could be an entity, and we'll talk more about who the trustee should be, but we're putting that trustee at the highest level in decision making on how distributions can be made for the beneficiary. And the beneficiary themselves do not have the ability to claw the money out and say, look, you've got to give me this, or you've got to give me money for that. It's going to be completely up to the trustee. So if that beneficiary ever has a personal life liability crisis, the trustee stands in the way of the outside person, divorcing spouse, creditor, person who's suing the beneficiary, stands in the way of those people getting into the assets that are within the Supplemental Needs Trust. So big part of what we're doing is making sure that those assets are there for when the beneficiary needs them.
I like the expression protecting from creditors and predators.
Creditors and predators. Yep, that's
A good one.
absolutely correct.
This is one of the case studies that we were talking about, the benefits that this planning can provide. So you can sort of read through that. And Doug mentioned this earlier and kind of touched on this concept of other relatives or loved ones that might want to be able to benefit that person as well.
Yeah, I'll mention just if you pop back to that slide. Sorry about that.
That's okay.
So we've got the case study that was provided here. And I just was going to say, this is talking about parents creating a trust for their young child who has some sort of cognitive disability, and using, their planning. So I'd say it's worthwhile just to note the most common scenario for us in our planning is, while we're doing wills and trusts for our clients, we'll of course naturally talk about their beneficiaries and if there are any things that they might need differently. And then client will invariably explain the situation. We'll say, oh, well, this is a solution for your problem. And then we'll write these trusts either proactively, creating the irrevocable trust, or we'll put them underneath of a will or underneath of a revocable trust so that they spring into effect after the clients pass away. So just worth noting, that's really the most common scenario where these come up for us.
Thank you, Doug. Talking about what the benefits are and why we create these trusts, like there are different types of these supplemental needs trusts, these special needs trusts. And it's really the kind of biggest distinction between them is the source of the funding of the trust. So a first party supplemental needs trust is actually the beneficiary's assets, different than what Doug was just describing, which is kind of the more common scenario, which is that a parent or a grandparent or other loved one is funding the trust for their special needs beneficiary. That's that third party supplemental needs trust. You are a third party that is putting the assets, your own assets, into this trust for the benefit of your special needs loved one. But this first party supplemental needs trust, that money is coming from the beneficiary. Frequent sort of sources of those assets are personal injury settlement, and inheritance. Maybe it's that beneficiary's own savings. The key is just that those funds legally belong to the person with the disability. The kind of really key factor in creating these first-party supplemental needs trusts is that there has to be a Medicaid payback provision. That means that when that special needs beneficiary, the person in the first-party trust who has funded it, when they pass away, anything that is remaining in that trust has to go back to the state. They're getting reimbursed essentially for any benefits that they have paid out. And that is a key feature of that first-party trust, first-party supplemental needs trust. The third-party supplemental needs trust doesn't require that. You don't have to have that Medicaid payback requirement because it wasn't that beneficiary who was contributing themselves. The primary purpose of both of these trusts is to protect eligibility for benefits. You are under a third-party supplemental needs trust. You are able, as the person that's funding it, the parent, the grandparent, other loved one, you're able to say, when my special needs beneficiary passes away, this is where I want the assets to go. This is where I would like them to transfer. It could be to other family members, to charitable interests, to anybody that you choose. There are also pooled trusts. So pooled trusts are managed by a nonprofit organization. So it's really kind of like a special first-party supplemental needs trust. It pools the funds from a number of individuals, but each individual has their own kind of like sub-account. They're a really good option when the amount of money that's going to fund the trust is relatively small. When there isn't anybody that, and we're going to talk a lot about like choosing trustees and who can do that job and what they have to do, but when there isn't a good candidate to be trustee, these pooled trusts can be a good option. Again, this is still a first-party supplemental needs trust. And so a Medicaid payback clause usually applies to a pooled trust, but there are circumstances, some cases, where the remaining funds can be kept by that nonprofit as opposed to going back to the state. So it'll all depend on what would be permitted in a particular circumstance. But it is not that same structure as under a third-party supplemental needs trust where you're allowed to say that these assets go to your chosen like remainder beneficiaries in the future. It has to go back either to the state or to that nonprofit.
So we've got some key considerations related to setting up the special needs trust or supplemental needs trust. As we're going through the process, we'll naturally have to talk about who is going to be in charge of the trust once it's up and running. And again, that's by up and running, I mean either because we're funding it immediately or it's being funded at the time client has passed away. So that person who's going to be in charge of the decision-making will be the trustee. And the trustee is going to have a lot of responsibility. We refer to it as a fiduciary responsibility because they're going to be in charge of these assets for other people, namely the beneficiary or the beneficiaries of the trust. And they're going to have to take care of the investment management and also the distribution decision-making. Like when should I make distributions out to or for this beneficiary? So they'll have to be knowledgeable of those laws that I was mentioning earlier and sort of joking about, like reading them and knowing about them. But this trustee has liability risks, so they have to be very careful about how they distribute to the beneficiary because that could impact the beneficiary's eligibility. So creating the trust is step one, but you're putting someone in charge as the trustee who's going to be making really important decisions on how to make these distributions and when to make them in light of the rules for Medicaid and Social Security eligibility as an example. So we talk a lot about who the trustee should be. And, we give clients the ability to select family members, corporate trustees, or even a combination of those too. So we're going to talk about it in more detail. Funding the trust. We're going to talk about what the source for funding the trust will be. Are you going to actively put assets in there? So we're going to put cash or securities into the trust. We're talk about the tax basis related issues if you're transferring assets immediately. You can fund the trust using life insurance, but you have to make sure you update or modify the life insurance beneficiary designation to direct it into the trust. So we go through the importance of beneficiary designations and how you could use the life insurance either that you have presently, or maybe you even think about purchasing additional life insurance that's dedicated solely to the idea of funding the special needs trust, with the idea of creating a pocket of assets that's there for that particular beneficiary and allowing the remainder of the estate going to, other beneficiaries that you have. Obviously, a big part of what we're talking about here is leaving an inheritance to that beneficiary. So the source of funding might be the fact that you've passed away and the assets that you have in your estate are being directed by your will or other document to flow into the supplemental needs trust at that point in time.
We won't cover it in great detail today, like assets that are more appealing and attractive and better to fund the trust with, but that is something that during our appointments we talk through in great detail, and making sure that those beneficiary designations on those different types of asset accounts coordinate appropriately.
Yeah. I mean, there's a lot that goes into this planning process, and our intention here is to really let you know that this is an option and an opportunity that you have. Unfortunately, we can't be completely exhaustive in our review here, but this gives you a good primer, gives you an opportunity to understand some of these key concepts. And obviously, if it's something that's applicable for you, you'll be able to get in touch with us, schedule a time for us to get together so that we can get more in depth into your particular situation. Just finishing that one concept of the funding of the trust, we see here settlements. So settlements is referencing a legal action that maybe is being settled. You'll see it, as Annalise had alluded to, where someone maybe was in a personal injury accident or medical issue, so that they're receiving a settlement as a result of legal action. And now you've got this big chunk of money. And if that beneficiary is disabled as a result of their accident or injury, and we want them to continue to receive the benefits, they have to go into the supplemental needs trust in order to maintain the benefits under those circumstances. Flexibility is a key component of creating these trusts. We want to make sure that they are flexible so that the trustee and people involved can adapt to changing needs and circumstances. Just because something is the way it is today, we all know things change, and we know that these trusts can be in place for decades. So what we're seeing today may not be the case 20 years from now, and we want the trustee to be able to update, modify the terms, and be able to flow with the changes. Okay, so as we're drafting, we'll continuously add clauses that we know have been impactful for other clients in the past, and we continue to update them and modify them over time. So our documents are ever changing and ever adapting, because we get to see how our clients' situations evolve and how beneficiaries' needs are evolving underneath of these trusts that have been created already. So it's really great for us because of our experience in handling these situations and having seen these scenarios play out. We're able to take that evidence and then work it into our documents and provide for future clients and beneficiaries in a way that we couldn't have without that experience. Yeah.
One of the ways we're really helping to maximize that flexibility is the use of a trust protector. Under these trusts, when we're drafting them, having a trust protector can be absolutely key to just efficient, cost-effective administration in the future. I don't know if you want to talk about the trust protector a little bit.
Sure. Yeah, we can go over the trust protector. It's trust protector is a great tool as a part of the flexibility process. So as I had said, we're always working to create flexibility for the future because we know these changes are invariable. They're going to happen. So what we're doing is we're naming a person or an office or advisor or an advisor's office to have the ability to do certain things that the trustee and certainly the beneficiary are not allowed to be able to do in order to kind of segment these different interests that they have either as a trustee or as a beneficiary. So we create this third position, namely the trust protector provision, and then we're appointing someone to fill that role, and then we're giving them powers and authorities, namely to update the trust after the trust has been created and funded. So if the trustee or even the beneficiary find themselves in a situation 5, 10, 20 years after the trust is funded that they can't quickly and easily remedy, they can go to the trust protector and they can say, hey, this is what's going on. This is what we're dealing with. We notice in the document that you have the ability to update and modify the terms of the trust. And we think this is a perfect opportunity for you to be able to come and help us to do that. And so it's great. We get this ability to create that ability to adapt to a need for change. So that's a whole nother topic. I mean, of course, we have to pick the right people to fill the role as trust protector. So that's another thing that we would be talking about too, like who fits that role. There's a longevity issue. So naming a single elderly person might be good for a short duration, but then you have to think about what happens when they can't do it. So, you can name multiple individuals, or like I said, you could even name an advisor or an advisor's office so that the successor within the office would take over if the individual themselves can't act. Some other things that will give the trust protector the ability to do would be fill a vacancy for the trustee position. So if you ever name somebody to act as trustee and suddenly they fail to be able to act because of an accident, injury, incapacity, they've passed away, and maybe there's no successor already listed in the document, the trust protector can be given the ability to name a successor. They could even remove a trustee under certain circumstances. That'll be up to you to let us know how you want that to be drafted, but a lot of clients like the idea, especially if they're naming a corporate trustee. They like to give someone the ability to remove and replace the corporate trustee or any trustee potentially. Yeah, if they start to act improperly, charge too much, they're not making distributions when they should, they're not being responsive to the beneficiary's requests. So the trust protector is somebody that the trust beneficiary could go to and say, I am having these problems with the trustee, can you help me? And then the trust protector could go to the trustee and talk to them. And sometimes the trust protector will find out that the trustee is actually acting properly and maybe the beneficiary is causing the problem. But that'll be up to the trust protector to really determine what's going on and figure it out. But if they find out the trustee is not doing what they're supposed to do, they'll have the ability to remove them and replace them and appoint a good successor under the circumstances. So it's a good safety valve, good opportunity for us to get out of a bad situation.
Big benefit too of the trust protector is that you can do in certain circumstances a lot of these things non-judicially. So everything we're talking about, you can go through the courts and pay lawyers to stand in front of judges and petition and ask for all of these things to be done. And if it's appropriate for the particular circumstance, the trust protector can do that outside of that court process, which is always a little bit less stressful and less expensive typically.
Yeah, anything that we're able to give someone the ability to do without going to court will make adapting significantly faster, easier, and less expensive. So that's really the core goal of the trust protector: faster, less expensive, and easier for the people who are involved.
Right. Faster, less expensive, easier. It's a motto to live by, I think.
Yeah, I mean, all those things are great. All right.
You touched on this a little bit, Doug, before, but let's dive into a little bit more detail when the supplemental needs trusts are being created and sort of the pros and cons of each of those things.
Yes. So the lifetime trusts, which again are referred to the inter vivos trust. Pro of doing that is you fund them now. So if you have an immediate need or reason to put assets into that trust, we can do it immediately. So that's really the deciding factor. Among, I'd say the second one probably would be the other that I did mention as well, where you have multiple families or family members who all want to contribute the same pot. And they might even be contributing to that pot at different times. So they don't have to put money in there at the same time. You could have one supplemental needs trust that's created today that will only be funded at the death of any of these multiple individuals who all say in their own will, when I die, X percentage of my estate gets paid to that trust that had been created. And it could be coming from different directions at different times. The bad side of the inter vivos trust is that you are starting, the cost of management and the process of doing it. So you're really just deciding, is it really necessary? Do I need to put those assets in there presently? Or is it something that could just wait until I've passed away and fund it then? Because, if you have the assets and you have the ability to parse the money out to the beneficiary and pay for things for them, maybe that would be the de facto supplemental needs trust, where you're just paying for things or helping them out along the way. And then you would simply have a will that says, look, if I'm not here anymore, then I'm putting these assets into that trust. And then that triggers the creation of the trust and the funding of it. And then that's where the administrative expenses begin at that point in time. Testamentary trusts. So certainly a positive is it's written into your will. So it does not exist today. It's simply verbiage or language that's written into your document, and it springs into effect at a future occurrence, which happens to be the point where you've passed away. And it gets funded then. And so that's good because you don't have the administrative costs now for the balance of your lifetime. And you also can modify that trust quickly and easily by simply updating your will. Because it's not an active document or active trust until you've passed away. So anytime you update your will, you can go in there and you can tweak who's going to act as trustee, what are their powers, what are their authorities, who's going to be trust protector. All of those things can be quickly and easily modified by you during your lifetime. A negative, to the extent that you would, really be super concerned about this is just a moderate delay in the access after you've passed away, because the trust will be funded as a part of the probate process, which is the administrative process after you've passed away. So it'd be a little bit of delay from the point where you've passed away until the assets go into the trust and the trustee is appointed to be able to access those funds. So, there's a little bit of a negative there, but there are other things that we work with clients on to make sure that there's a little pool of ready money to be utilized to cover the gap. And when we're saying a delay, we're not really talking about like years or anything like that. We're talking about a matter of months probably until the entirety of what's going into that supplemental needs trust will be accessible. But prior to that, depending on who's involved, usually there are very practical solutions that could be handled under the different circumstances.
Right. I think that you did kind of cover why you might choose one of these options over the other as you were describing them. But are you seeing clients typically maybe that have less available resources that might be worried more about being able to take care of their own needs during lifetime, generally skewing towards the testamentary trust side and approach?
Yeah, I think so. I think, frankly, I'd say overwhelming majority of our clients who create these kinds of trusts, the supplemental needs trusts, are doing it through their wills or underneath of their revocable trusts, which is a whole different type of trust plan. But if you're using the will or the revocable trust as your core estate planning document, they're writing the supplemental needs trust for their beneficiaries underneath of that trust to spring into effect after they've passed away. I'd say that's at least 80% of our supplemental needs trust planning done that way. And then we've got 20% of our clients who are doing those trusts, creating them as active administrative trusts today. And I think, as Annalise was saying, a big driver there might be what the client's financial situation is, whether they really have the assets sufficient to take care of themselves, and whether they can afford to transfer significant chunks of money out of their personal funds and into a supplemental needs trust today. Because once those assets are transferred into the supplemental needs trust by the client, they're not really theirs anymore. So they can't really take the money out and access it for their own use and enjoyment. So they have to be very careful about what they transfer to the irrevocable trust, because those assets are no longer theirs. And we have clients, as I say, who decide they want to do that. It's just after a long, thoughtful process of determining what's appropriate in their given circumstances.
So regardless of whether the supplemental needs trust is going to be a lifetime trust, if it's created under a will, under a revocable trust, there are some common, useful, helpful clauses and provisions that we want to see always included in a supplemental needs trust that would qualify it, I think, as well drafted. So I think you're going to talk about a few of those, correct?
That is correct.
Okay.
Yeah, the number one most important provision is the distribution standard for the supplemental needs trust has to be purely discretionary. So the trustee will have the complete discretion on when to make distributions out to the beneficiary. So you'll see it written right into the document. Usually says income or principal can be distributed to the beneficiary at the sole and absolute discretion of the trustee. And that's important because it cannot be, it cannot give the beneficiary any ability to require the trustee to make distributions out to them. If the trust beneficiary had the ability to require distributions, then that would disqualify them from these government benefits. And it also might make the assets susceptible to divorce creditors and lawsuits as well. So we have to give the trustee this ability to make distributions based on what they see is going on at the time, based on what they know to be the circumstances, and we have to trust the trustee to make really good decisions. And that should be contrasted with what we call HEMS, which is health, education, maintenance, and support, which is another common distribution standard for trustees who are giving assets out to beneficiaries. It's just that in the supplemental needs trust scenario, we cannot give the trustee the ability to distribute for health, education, maintenance, or support, because when you do that, you're actually saying that the trustee has to make distributions if the beneficiary has a health need, an education need, maintenance, or support. And so health, education, maintenance, and support are things that would then disqualify them from receiving Medicaid or Social Security, because those entities, whoever's in charge and the caseworker for Medicaid or Social Security is going to say, look, this beneficiary already has a resource, which is this trust. And even though it says this supplemental needs trust, the reality is the trustee has to give money out for health, education, maintenance, and support. So we're not going to distribute through Medicaid or Social Security for those things because they already have that trust in place. And so they would say, look, you've got to tap that trust out until it's gone. And when there's nothing left in that trust, get back to us, and maybe that beneficiary can requalify for Medicaid and Social Security. So that is obviously a horrible result And that's why you really have to check that distribution standard and make sure it says sole and absolute discretion of the trustee and not health, education, maintenance, and support for the beneficiary.
Yeah, I don't think you can stress that one enough. I've had a lot of clients come in with existing documents from elsewhere, and they think that they have trust planning that's protecting their special needs beneficiary because they have a trust that has this HEM standard, and it does not accomplish that goal. Another useful provision to include is the spendthrift clause.
Well, the spendthrift clause, well named. The intention behind the spendthrift clause is to make the asset protection component as strong as possible and paint a very clear and bright line for the trustee who is having to decide when to make these distributions out to or for the trust beneficiary. And so what you could potentially have is a scenario where the beneficiary is in a legal entanglement, most common again, divorce, creditor, lawsuit, and whoever they're dealing with comes knocking on the door of the trustee and says, hey, we know this beneficiary has a trust and we want you to pay us out of the trust because they owe us for this, that, or the other thing. We want the trustee to be able to quickly and easily say no. And so this spendthrift clause will, that under no circumstances is the trustee permitted to make distributions to a third party, like a divorcing spouse, like a creditor, or someone who's suing the beneficiary. So the trustee will be able to say, well, even if I thought you deserve to be paid, I'm not allowed to pay you. So it's a clear line for the trustee to be able to say, I wash my hands of this responsibility. I don't even have to investigate into the situation as to whether you really deserve to be paid or not. This document says I am not permitted to make payment to you. So it's good for the trustee as much as anything because it keeps them a little bit out of the line of fire. Even though they might get this call, they can always fall back on the I'm not allowed to do it. So they don't have to look into the circumstances at all. And that's really what we want, because we want these assets to be there for the supplemental needs trust beneficiary. We don't want these third parties to be able to easily get through the trustee and into the assets.
Also, the beneficiary, if they were sort of trying to say, well, I have this interest in a trust and maybe I can sell that interest to you, you know, that they would be able to get some kind of lump sum payment saying that, oh, well, I'm entitled potentially to future distributions. And if you give me this now, I'll allow those distributions to go to you. It prevents against the beneficiary that's trying to do that as well. Anything that a beneficiary could potentially like sell an asset from the trust could be considered a countable asset for qualification purposes as well. So another important reason to have that clause. Another important reason, and we're talking about the trust protector and what happens if somebody that's been named as a trustee can't act. One of the reasons that it's really important to appoint a successor trustee, and why that's a clause that we always like to include, is because anything can happen. Like you were saying, we want that flexibility. If somebody has become incapacitated that you had appointed as trustee, we want somebody to be able to swoop in and do that job.
Yeah, the successor trustee is frequently overlooked. You know, you'll see documents come through our office that have been prepared previously, and maybe they'll stop at the first level. You know, people, I think, will surprisingly have a difficult time thinking of who will fill the role as trustee, and then they'll finally figure out who they want to be the initial trustee, and they'll be like, you know, now I've decided on the first person and I'm good. The reality is that that first person might not be able to act forever, and we need someone else to be listed as the backup. And and we talked about earlier, we have the trust protector in the documents that we prepare, but shockingly, quite a few documents that are written elsewhere do not have the trust protector provision, because at least the trust protector provision will give someone the ability to fill a vacancy where there is no trustee. So we like having the successor trustee written into the document because it's nice and clean and clear and allows the client to be able to appoint that person. But we also will create these other or secondary ways of filling vacancies as well. So we're not stuck. Last thing you want is a rudderless ship where there's no one acting as trustee and now no one's there to take care of the investment management. What if you have a topsy-turvy investment time, in the stock market, and the assets are maybe going down significantly, and there's no one there to act as the trustee? Who's going to stop the bleeding if those assets are going down significantly during that period of time? Just as an example, what if the beneficiary needs something and there has to be a distribution? God forbid, they have this financial need and there's no one acting as trustee. How are we going to get them the money? So successor trustee, super important. Trust protector with the ability to fill vacancies, also very important. So the trust beneficiary, the supplemental trust beneficiary, obviously has a life expectancy. And when they pass away, we need to have clear direction on where those assets go when they pass. Is it going to go to their siblings? Is it going to go to their children? Maybe they have kids. Is it going to go to a charity? Is it going to go to whomever you want it to go to? You have to spell it out underneath of the document and be very careful about structuring it that way and put in successors under those circumstances as well. So don't just name one person, because what if that person dies before the supplemental needs trust beneficiary, and then we're having to distribute the assets maybe to the wrong people based on what the law rules state under the circumstances. So you have to be really careful about that. So that's one of the things I think it's important to stress, because of our seeing these things play out. We know about all these important provisions, and we're thinking way ahead for you and making sure that all of these things are addressed underneath of your documents, so that the people who are involved later, for you and in your family and for your friends or whomever you're creating these trusts for, so that they have the best trust possible with as much flexibility as possible. It's funny, I'm sure you run into this, Annalise, will frequently have clients who come in, we go through the discussion about the planning process, and then they'll come in to see us to review the documents and sign. And on occasion, they'll have this kind of frown on their face, and they'll say, "Why is my document so long?" And they'll say, how could you put all of those provisions in that document? And I always laugh. And eventually they're fine. I explain why they're all the provisions are there, and they ultimately feel very comfortable with those provisions. But I do laugh about it, because when you go out somewhere or you buy something, invariably you enjoy having something that's more. You get more for what you paid for, and you're thankful. Very rarely do you go and say, I wish they didn't, I wish they didn't give me so much of that good stuff. So in our trust, the document will be fairly lengthy. The purpose of the lengthy document is not to charge you by the pound, which is something some clients have said before. It is to give you the best document possible. And most of what is in the document is flexibility and adaptability and powers to the people who will be in charge, the people you're trusting to take care of your loved one. So we want them to have the ability to adapt to these situations. So all of these,
it's counterintuitive, and that's what I frequently say to clients. Just because the document's lengthier, it's not actually more complicated. It has the opposite effect, which is that it makes everybody's life, like on the back end, easier and simpler.
Yes, we want to give them the power and authority to deal with difficult situations, because it's quite possible that difficult situations will come up, not because of the document, but because of the life scenario of the particular beneficiary. And so we want that trustee to have the ability to help them the best way possible. So that's what all That's all these clauses are for. So these are useful and important clauses, but I just thought it was important
The
to,
interest of full disclosure, they
Yeah.
do make the document a little bit longer.
yes, the more words we have to put in, the more pages.
Not charging by the word either.
Yes.
Neither the pound nor the word.
Annalise wanted to charge by the word, but I said no.
So we keep talking about the trustee and sort of things that the trustee has to do. And we're going to talk as we move on a little bit more about who is the trustee and who should that be and how are you making those decisions. Before we do that, let's talk just about like trust administration in general. Like what are the best practices related to that? What are the things that the trustee has to do? You have to keep accurate records. You have to adhere to the terms of the trust. And you have to pay a lot of attention to the investments, the investment strategy, review what's happening with the trust assets. It is not just sort of I've been appointed as trustee and then just once and done. It's an ongoing job that evolves over time. Record keeping is just one of the most critical responsibilities in trust administration. Maintaining accurate and detailed records is just crucial. That includes documenting income that's coming into the trust, expenses that are paid, any distributions that are going out. It's not just really a best practice. That might not be the right term. It's essential for complying with the requirements of these government benefits programs. There are frequently audits. You do have to recertify for benefits regularly. And so being able to quickly and easily produce detailed records is really important in that context. Also, it helps to ensure transparency and ultimately protects the trustee. If you have great records and somebody sort of alleging perhaps that you had done something that you shouldn't have done, you now have all of the proof that you have been dotting the I's, crossing the T's, and doing everything that you're supposed to be doing and have been totally above board. Adhering to the terms of the trust, you have to follow essentially the rules that are set out under the trust document. As the trustee, you don't get to decide what should happen. You are constrained by those terms. The trusts, as we've been discussing, really specific about how funds can be used, the kinds of distributions that can be made, what those standards are. For example, and Doug, you were talking about this before, the majority of these supplemental needs trusts, that funds can't be used for like food or shelter, like some of these basic needs, without potentially affecting the eligibility for these benefits. So you have to pay close attention to those terms. You have to understand those restrictions, only make allowable distributions to be in compliance with the rules of the trust and the terms for those public benefits. I always like to include a clause that says that the trustee does have the discretion to sort of make distributions for these things that would typically not be permitted if something happens and it's actually in the best interest of the beneficiary. And so if for some reason somebody's benefit amount is beneficiaries receiving their public benefits, it's covering their basic expenses, but something happens and the amount that they're entitled to receive drops drastically, like significantly, down to the point where it's really just not covering any of their basic needs anymore. I like to say that the trustee has a discretion in a situation like that to make distributions that might disqualify them, because in that kind of a circumstance, and that's that flexibility that we're talking about, that kind of a circumstance, you want that beneficiary to actually better for them, to be able to use the trust assets for these basic needs, as opposed to having the benefits because those benefits just aren't cutting it anymore. So you do have that. I like to include that always. And I always like to point that out to clients, because there is that concern. Have I locked up this inheritance, these assets, in such a way that should my special needs loved one really need to access them, that they can't? And the fact of the matter is, we draft and it makes the document a little bit lengthier, including that clause to provide for that potential. Investing and regular reviews. It is not, like I said, a set it and forget it situation. You do have to regularly review the trust assets, the financial health, the investment strategy. As a trustee, you can employ advisors. You don't have to sort of manage all of that completely on your own. The trustee really just needs to make sure that the trust is just being managed in a way that is responding to any kind of changing needs, both the needs of the beneficiary, what's happening in markets, what type of investments are held in the trust. And so reevaluating distributions, updating advisors, things like that, the trustee has to pay a lot of attention to. This is a case study. We're about to talk kind of about the idea of family trustees versus corporate trustees. You can read through this, some of the things that you might encounter as a family trustee. If you have appointed somebody to act, it's a family member, and they take on this role and then they realize that it's maybe a little bit beyond them. There are options for them. And it's a good segue into our next slide, which is this idea of kind of what are the pros of a family trustee? What are the cons of a family trustee? Corporate trustees, why would you want to have a corporate trustee? Why would you not? So when we're thinking about naming family members as trustees, one of the big benefits is that that family member typically really knows that special needs beneficiary really well. They know them personally. They understand what their strengths are, their weaknesses, what their preferences might be, routines, challenges that they face. And that kind of insight is like priceless. It's really valuable when you're making day-to-day decisions for a beneficiary. Family members also can be really cost effective. And so you will frequently have family member trustees that are appointed and they are not charging any kind of fee whatsoever, or maybe a smaller fee than a professional trustee might charge. And that can help to preserve trust assets over time. The kind of downside sometimes to a family trustee is that they are lacking in expertise. They may not have the legal and financial kind of savvy that's required to be able to do this job entirely on their own, to manage a supplemental needs trust. And making a mistake, a misstep in that context can have really terrible impacts and outcomes. You can jeopardize public benefits, cause unintended and disastrous sort of consequences from a tax perspective as well. So that sometimes is a barrier or a reason why a family trustee maybe shouldn't not be appointed, but perhaps shouldn't act alone, shouldn't be the only trustee that is appointed. And so appointing a corporate trustee can really be beneficial to have either acting on their own if there isn't somebody in the family that makes a lot of sense, or acting together with a family member. The benefits of having a corporate trustee are that they have that experience. They know how to read the terms of a trust, understand what those distribution standards are, manage the investments, and do all of that work that the family trustee might struggle with a little bit on their own. One of the things that I always talk to clients about in detail is really the family dynamics. That's can't be underestimated or understated how important that is. Just because a family member maybe does have the financial savvy and would be able to act on their own without a corporate trustee, if there is a dynamic and a relationship there that is really challenging between, say, maybe one sibling and then the special needs beneficiary is their sibling, and there is already tension there, putting that sibling into that position where they're dealing on that level with their special needs sibling could be really challenging and sort of exacerbate something that is already there. There are a lot of clients that I meet with, however, who have one sibling and then the other sibling, the special needs beneficiary, and they have this ongoing like great relationship. And the special needs sibling has for a lifetime depended on the other sibling. And that's a natural fit generally to have that sibling act. So really fact and family and client specific, what will make sense there. But those are the things that we talk to you about and kind of work through and see what's going to be the best fit for you.
Yeah, I'll just mention about this decision-making on the trustee appointment. It's really important component of this whole thing because I think it's important to think about the the fee issue because invariably people will be price sensitive. And you had mentioned, maybe a family member might not charge a fee, but obviously a corporate fiduciary would. When clients are appointing a corporate fiduciary, the goal is for them probably to save money for the beneficiary in the long run through a combination of proper investment approach, tax management, so good tax decisions, and also making distributions that do not disqualify the beneficiary from their benefits. So you could see, let's say a trustee was charging 1.5% or 2% on an annual basis for all the work that they do. You could see through proper investment management or tax management, or again, not disqualifying them from the beneficiary from benefits, how that trustee could easily make up 1.5% or 2% through, doing things the right way. So you really have to examine it, because there's like a cost, meaning how much you pay for something, but there's an underlying cost if the person you name isn't doing a good job. So you really have to analyze that and recognize that that's a possibility. And also, the corporate fiduciary has longevity. We've talked about this for other things, but longevity meaning you name this corporate trustee, a bank or a trustee, professional trustee, it's going to be a person who's in charge of your case file. But if that person isn't there anymore, the next person in line will step in. It just will naturally segue to the next experienced person. Whereas if your family member that you're appointing as trustee suddenly can't act, they don't have someone who's next in line. So you just have to think about all these things. That appointment of the trustee is a very important component. But I have to say, having the corporate fiduciary in the supplemental needs trust arena is a big help. And I've seen this play out in countless situations previously.
There are a number of corporate trustees that are focused almost exclusively on supplemental needs trusts and filling that role.
Yeah, it's true. All right. So just talk about the beneficiaries of these trusts and recognizing that you can, if you would like, have a single trust for multiple beneficiaries. And you could have one core beneficiary, meaning the person that's really intended to benefit them, the person with the supplemental needs. Or you could have multiple beneficiaries with this maybe same or different kinds of special needs. And so you have this single trust for these multiple special needs beneficiaries. I tend to create separate ones, but you could have a single one that sprinkles out for multiple beneficiaries if that's determined to be the absolute best in the situation. We frequently will include the possibility of distributing to another person or another group of individuals underneath of that supplemental needs trust. So even though you might create this one supplemental needs trust for your child, you might say that the trustee also has the ability to distribute something like the income for one of your other children or multiple other children of yours, even though they don't have any supplemental needs or special needs. And the purpose for including the additional beneficiaries is really not with the expectation that those people get the distributions. It's that if someone comes knocking later on the trustee's door and says, we want to be paid from this trust, they'll have another argument, which is this trust is not only for this recipient, but it's also for these other people. So if we start giving money out of this trust to this particular beneficiary, it's going to negatively impact these other beneficiaries. So it's a way for us to create another argument why that trust should not be invaded, why it's not an eligible resource for payment for the person that we're truly trying to preserve benefits for. And then, of course, like we've talked about, we have to be mindful of remainder beneficiaries. So in the third party trust, which is the trust that you are deciding to create proactively for another person, either during your lifetime or through your will, So the inter vivos versus testamentary. So if you're creating that trust for a beneficiary, you can have remainder beneficiaries. So you can say, it's in this trust, it benefits this person for the rest of their lifetime. And then when they die, the remainder of their trust goes to fill in the blank. We have to decide who gets it when that beneficiary dies. However, if the type of supplemental needs trust that's been created is a first party supplemental needs trust, which again is the kind of trust that gets created as a result of a personal injury settlement, or maybe even a big inheritance that wasn't going into trust, you could create a first party trust in those situations as well. So if you have that kind of trust, the deal that you basically make with the government is they're going to let you keep that money in that supplemental needs trust to benefit the beneficiary for the balance of their lifetime. But when that beneficiary dies, the government entity that had been providing benefits gets to be reimbursed out of the trust first, before the remainder of that trust is given out to anyone else. So if that beneficiary was on Medicaid and there was $1 million in their trust, and during their lifetime, they received $500,000 of Medicaid benefits, and the beneficiary dies, the Medicaid people will come and say, we have a bill for $500,000 that we want to have paid back. And so the trustee of the trust has to give the first $500,000 to Medicaid, and then the remaining $500,000 would be split among the remainder beneficiaries that had been set there. So that's just an example, gives you an idea of this scenario, but key component and key difference between the third party and the first party supplemental needs trust.
So we've been alluding to this, I think, throughout, sort of what are some big mistakes, missteps, common pitfalls that can be made and that we want to avoid.
Yeah. So, we've talked about this a lot, but I think reiterating it is important. Improper distributions is a huge pitfall. So this trust is created for the beneficiary, and the distributions are for the sole and absolute discretion of the trustee. So the trustee is making these decisions, but they could make a bad decision, and they could make too significant and too frequent or distributions for the wrong things for the beneficiary. And as a result, the money that the beneficiary is receiving could cause them to no longer be qualified for Medicaid or Social Security or some other benefit that they're receiving. So it's imperative for the trustee to be making distributions that are appropriate and within the framework of the rules of the benefits that the beneficiary is receiving. And that dovetails into the lack of trustee training. You could imagine appointing an individual as trustee who has never dealt with these situations before in their lives, and they read the trust and all it says is that they have the ability to make distributions for sole and absolute discretion at their sole and absolute discretion. And so they decide, I'm going to make distributions all the time and give the beneficiary whatever they want. And then Medicaid or Social Security finds out that these distributions are being made and that the beneficiary is living a much higher lifestyle. And so as a result, they might come and say, you know what, that trustee was giving money out for all of these things. So now the beneficiary cannot qualify for the benefits that they were receiving before. So that's obviously a trustee training issue and goes back to the selection of trustee and making sure that you're either picking someone that either already has trustee training, or maybe thinking about making sure that the person that you appoint gets training at some point before that trust gets set up. Failure to update the trust or to update to changes in laws or regulations. So obviously, if you've created a testamentary trust, which is again the one written into your will, you can update that quickly and easily by modifying your will during your lifetime. So if you find out through a review with your attorney or some other article that you read that there's something new in the law and change that maybe should be made, you can come and you can modify your will and make the changes to the document that are necessary to make sure that the trust works optimally after you've passed away. But you could also have already created a trust. And so the trustee needs to be cognizant of changes in the law and changes in the personal life of the beneficiary. So they too can update and modify the terms. It's just that it'll be different depending on the particular situation and how the trust was written. So if this is an irrevocable trust that's been funded, the trustee might have to go to court to get approval from a judge to let them make a change, which might or might not be granted under the circumstances. And obviously will mean that you've got the cost associated with that and the delay associated with going to court. Or if the trust had been drafted with the trust protector provision that was pretty broad and gave the trust protector the ability to update and modify the terms as necessary, the trustee would be able to go to the trust protector and they can update and modify the terms based on the trust protector's powers. So it's important to keep an eye on these trusts, either if you've created them underneath of your documents and have the ability to update or modify them, or creating the documents with the provisions that are necessary to allow for the trustees to update the documents later after you've passed away or after you've funded the trust.
Doug?
You're welcome.
So I feel like we've learned a lot so far. Well, I hope you guys have.
I mean, I have. Thanks, Annalise.
You're so welcome. I think that all of you are here today because you have either the knowledge that this is something that you likely need, or because you suspect that perhaps it is. Now that we've given you kind of this primer, I'm sure a lot of you are thinking like, well, okay, what do we do next? Like, how do we get the ball rolling? Like, how do we start this process? First step that's really important is just like assessing the needs of your special needs beneficiary, your family, your overall estate plan. And a lot of that starts with like assembling a good team. I think that a lot of folks procrastinate on thinking about and doing this kind of planning because it feels overwhelming and they're not sure where to start. We have a lot of clients that come to us and they have a child or a grandchild or other loved one that's already receiving benefits. And so it's kind of a no-brainer at that point. Like, yes, this type of trust planning likely makes a lot of sense for you. Let's figure out what the best way to incorporate it into your planning is. But we have some clients who have this special needs beneficiary who maybe they're providing for during lifetime, and they haven't needed to qualify for benefits yet. And they don't really know, like, what, if I'm not here, if I'm not able to do this for this person, like, what are their options? What are the resources available to them? There are like disability life planning providers that can help you navigate that. Like, what is that person's specific needs? What are the benefits that they might be eligible for? And so you can work with somebody that does that and provides that service. That we're happy to provide a referral. We know quite a few that do a great job and have been like an invaluable resource to clients. And so assembling that team, maybe that's the life planner in combination with us, your legal team, working through all of the issues and the considerations and choices and decisions that we touched on today. Figuring out what type of trust planning makes the most sense, how is the trust being funded. I think as you've gathered from the presentation and we've been talking through things, this is very complex planning. This isn't something that is simple. So you do need a really experienced team to be able to advise you, analyze all of the issues, get all of these really important considerations sorted and implement an effective strategy. So it's the figuring out like, what are we going to do? How are we going to do it? And then that ongoing administration that we've been talking about. So you can't really sort of underestimate like how important that team-based approach is. Something we didn't talk about that I think warrants mentioning is, yes, there's we want to transfer assets to our special needs beneficiaries and do that in the best way possible, but also lifetime decision-making for special needs beneficiaries, powers of attorney, guardianship, making sure that those things are in order as well. That is something we can also assist with. That's kind of outside of the scope of what we're talking about today, but it's something that I think should be on your radar for sure. The next steps to clarity. What do you need to do as that first step? Yes, we need to get the team assembled, get everybody on the same page, and that starts with giving us a call or shooting us an email. Our phone number is right here. For those of you that are existing clients, we may have sort of a lot of records and information already on file that we'll be able to use to assist in formulating a plan for you. If you're a new client or you haven't been here in a while, we may need to gather some information from you, but giving us a call or shooting Lisa Snyder an email to get that ball rolling and to get the process started is your first step. Getting us introduced to other team members if you already have a disability life planner, if there's an accountant, an advisor that you're working with, getting us all in touch with each other so we can be on the same page. After you give us that initial call is a good game plan, I think. Doug, anything to add there?
Yeah, I was just going to say, if you don't have a team at all, because we do this so frequently, we can also introduce you to other people that are important in that process. Disability life planner, corporate fiduciaries, investment advisors who are knowledgeable in this arena. So we work with countless advisors and have many clients who have different advisors. So we've had opportunity to see people who do a great job for their clients, and we would be more than happy to put you in touch with them as well.
Absolutely. We'll help you assemble your team.
Yeah.
Our final thought, thoughtful and well-informed planning now ensures peace of mind and long-term protection for you and your heirs.
Oh, that's beautiful.
It is. Yeah. It's really true, though. It might sound corny, but it's true. I always say that estate planning in general, this kind of planning, it's not something necessarily that folks find to be fun. I don't expect cartwheels like in the parking lot when you leave our office, but I think it gives you such good peace of mind.
I mean, it's mostly because our clients are frequently elderly. So they're not usually doing cartwheels, but inside, I think they're super excited.
Internal cartwheels, maybe.
Yes.
Certainly a very good night's sleep that night after you execute your documents, knowing that you have a really good plan in place to benefit your loved ones.
Yeah.
So thank you so much for joining us today. We are going to make the slides available to you, so you will get a copy of these slides. We do also have a supplemental needs trust report, and we'll send that over to you as well so that you have good resources to refer back to, and give us a call. We will look forward to hearing from you soon.
Thank you very much.